Si tutengenezee hizi vitu haraka.
Tomatoes. Unataka kupeleka saizi.
Absolute terms with no derogation or qualification in certain circumstances, but also on the other hand, it has an inbuilt constitutional clawback or derogation. And my Lord, where the court decides that the applicants have a right to bail, then there is no derogation. It is an absolute right. But my Lord, where the court denies the right due to compelling circumstances as provided for in 49H, then there is an absolute derogation. The right has been taken away. My Lord, in light of the submissions by my learned friend, conceding that this is a case where the right to bail is available, it means they have considered that there is completely no fetter, no derogation, and no clawback in the circumstance. In other words, the court gives bail as an absolute right, and it does not lie on my learned friends to set certain conditions when they have considered to it that this is a case deserving of the right to bail. My Lord, when I come to the general principles that guide the court on the grant of the right to bail, this is an area of the law that we have rich case law, and the judiciary, my Lord, has a very comprehensive bail and policy guidelines published in 2015, 36 pages, and it's fairly comprehensive. My Lord, in that bail and bond policy guidelines, it sets two criteria to consider when the court is looking into the right to bail and bond. And the first one, my Lord, is what is called primary considerations. There are certain primary considerations you look into. And the second one, my Lord, is secondary considerations. My Lord, the primary considerations are based on constitutional rights and principles, and they take preference over the secondary considerations. And the first primary consideration the court needs to consider is the accused presumption of innocence under Article 50, subsection 2 of the Constitution. So, my Lord, when you are looking into the totality of the matter, that is the substratum of the issue you must have in mind, that the accused persons, despite the terms you set, despite the conditions you set, at the end of the day are innocent. And the terms should never, ever color that presumption of innocence. It's a primary consideration. My Lord, the second primary consideration the guidelines set for you is the accused person's liberty. Very important consideration, a bill of right. And my Lord, the guidelines provide that you should not take the liberty of that person to stay with his family, to stay with his children, and to continue with his normal functions and duties. Again, my Lord, that is a primary consideration set by the Constitution. The third issue, my Lord, is the accused obligation to attend trial. It's a very important consideration, my Lord, again, for the court to ensure that the accused persons do attend trial. My Lord, the fourth primary consideration is that the court set reasonable bail and bond terms. And my Lord, that reasonable bond and bail terms, again, is premised on the importance of the right to liberty and the presumption of innocence. My Lord, if you look at the guidelines, they say that those terms should be made to ensure the accused person is present during the trial. Because, my Lord, the court must ensure that the accused does not abscond. So the terms you set should be all geared towards ensuring that the accused persons do attend trial. It should not be excessive, my Lord. It should not be sensational, my Lord. It should not be collateral, my Lord. It should not be extraneous. Those are the 4 issues the court needs to guide itself. But, my Lord, when you are setting that terms again, as I will show you later on, it all depends on the peculiar circumstance of the case. And I will show you later on, my Lord, when I address this issue, that this case has certain factual metrics that are so distinct from the cases you have previously tried or given certain conditions. My Lord, another primary consideration you should look into is the right of the accused persons and the interest of justice. But, my Lord, let me go to now the secondary considerations you should look into. My Lord, the first secondary consideration you should look into is what's called the nature of the charge or the offense and how serious it is. My Lord, when you look at the charge sheet, and my Lord, it's unfortunate that although we have many case laws that have tried to do away with the ambush by trial, I don't think it's fair for the prosecution to give us the charge sheet on the very minute when the plea is taken. If we had more time, we will have shown that actually there is no crime disclosed in this. There is no crime, absolutely no crime. And, my Lord, I'm sure at the trial we will show you that even the issues that are raised of money being transferred one account to another account does not offend even the ISPAC rules. I mean, that the ISPAC rules of accounts, even that is not offended, leave alone any other statutory provisions. But, my Lord, when you look at the charges, the offenses that the 5 accused, especially, my Lord, the second to the 5th accused persons are accused of, is transferring from money from one account to another, from one bank to another. There is not a single charge, my Lord, that says that money was lost or money was misappropriated in a legal sense. My learned friends use the charge sheet in a very literal sense when they say misappropriation. My Lord, there is no charge that money was lost. There is no charge that money was stolen, my Lord. There is no charge that money was misused. What the accused persons are being accused of is mismanagement of money in a commercial sense, qualitative and quantitative analysis, that probably they built a building of this instead of this, or with these windows instead of those windows. My Lord, we will show you at the trial that that does not constitute a criminal offense in any of our statutes. My Lord, another issue, my Lord, another secondary consideration the court normally considers is what's called the strength of the prosecution case, the evidence, my Lord. And, my Lord, in the manual it says it is not how the charge sheet is framed that determines the strength of the prosecution, but rather the evidence. And, my Lord, again, it's unfortunate that we don't have the evidence. I know there have been push and pull on whether evidence should be supplied before a plea is taken. But I think, my Lord, that's one of the issues that the courts will address. Third issue, my Lord, is the character of the accused persons, the likelihood of interfering with witnesses, and other issues. My Lord, let me address you, especially the accused persons, because my learned friend has taken a lot of time on it. My Lord, the first accused person, my Lord, is the governor for county of Garissa. My Lord, county governments are one level of governments, just like the national government under Article 2, subsection 2 of the Constitution. My learned friend, my Lord, has cited a number of cases that have created earthquakes and various aftershocks in the governance of county governments. But, my Lord, if you look at the case of both Francis Waititu and the case of Moses Kulai, and then compare with this case, my Lord, these are the distinguishing facts the court should consider in addressing my learned friend's submission that the first applicant should be barred from office. My Lord, firstly, this is a case, my Lord, that where no money was lost. There's not a single penny of the county government of Garissa that has been lost, unlike the allegations made in the case of Kiambu or even Migori or Marlal, my Lord. So, my Lord, that's very important, where not a single penny has been lost. That is an important consideration for the court to look into. My Lord, again, the second important thing is that there is not a single allegation in the charge sheet made against the first accused persons that he participated in the pilfering or the loss of money. My Lord, if you look at the allegations in count number 2, my learned friend says that he has not provided leadership. I have never seen a criminal offense, I have never seen a criminal provision that measures the quality of leadership and says that if you don't provide a good leadership quality, you provide a criminal offenses. My Lord, we will look into this another time. But the elasticity of the charge sheets my learned friends prefer against certain cases is very troubling. Because, my Lord, a criminal case when you prefer need to be very, very concrete criminal case that does not use words like mismanagement or lack of leadership, my Lord. My Lord, the third issue is that you have not been shown, unlike other cases, where the money has been transferred from the governor's account or the county government of Garissa, going to his wife, going to his children, going to his relatives, going to his sidekicks. My Lord, that is a very important criteria. No evidence has been shown or no allegations has been made that the governor of Garissa and his family or his friends or his relatives have benefited from this issue. My Lord, witness and accused persons will interfere with witnesses. That allegation, my Lord, is not a state of mind. It's not something that is in the mind of the DPP and its officers. It needs, my Lord, empirical averments on how the accused persons has previously attempted or is likely to attempt to interfere with witnesses. My Lord, it's a very important allegation. It's a very serious allegation that weighs heavy in the mind of the court when you are given bail. But it is an allegation that must be grounded on empirical evidence, factual metrics, dates, instances, and evidence, my Lord. In the absence of that, my Lord, you cannot take that state of mind, my learned friend's state of mind, into consideration. My Lord, I think I've distinguished the two cases my learned friend has cited, especially paragraph 48 of the Waititu case, in terms of the charge sheets and the issues that those governors was facing. And my Lord, that should be the end of my submission unless my learned friend, is there anybody wants to?
Yes, one.
Yes. My learned friend wants to add one single issue. So, my Lord, in summary, we're saying that give us bail on a reasonable terms. There is no need to deny any of the party or the first accused person access to his office. There is no correlation, my Lord, between that office and the offense created. The transfers that are the substratum of this case from one account to the other are done by the second to fifth accused person, and the governor, my Lord, has nothing to do with this.
Then I wish to associate myself with the accused person.
Is there anything like that?
And to briefly, Your Honor, just add the following. In considering the bail terms on which we will admit the accused persons, to borrow from my learned friend Mr. Okello's submissions, Your Honor is obliged to consider the weight of the offences. I submit, Your Honor, in considering the weight of the offences, Your Honor should consider the nature of these offences. My learned senior colleague, Your Honor, has submitted at length that in respect of these offences, they are offences really, the majority of them under the Public Finance Management Act, and there is no allegation that there is any benefit either to any of the accused persons or bestowed by the acts of the accused persons on anyone else unlawfully. And Your Honor, I submit that the contents of the document annexed to the charge sheet as Appendix 1 is of cardinal importance when Your Honor retires to consider the nature of these offences. Your Honor will note that it is at the end of the charge sheet. It is the last document in the charge sheet if we have the same document, Your Honor. It is blank. At the appropriate time, I'm sure the prosecutors will apologize for that. It's important to note the beneficiaries of these accounts. The beneficiaries of these accounts, Your Honor, are either the county government of Garissa or the Garissa County Development Fund. You know, with tremendous respect to the prosecutors, these are perhaps clerical errors or accounts or mistakes that have been made. There is no loss even to the county government. There is no benefit. And Your Honor should consider that. And I urge, Your Honor, the nature of these charges mitigates against mitigates in favor, Your Honor, of the accused persons being admitted to bail on nominal amounts, which I submit are sufficient to secure their attendance at this trial.